I'm joined by Michael Hallinan from Townsends. You're a special counsel. That's
Yeah.
like the best, isn't it? That's the top.
Oh, yes, I believe that.
Yeah, I know it. You have the great title of life after death. Is there life after death? I suppose that's Kerry Packer didn't see it, but what do you think?
Well, there is for the people who survive, and the issue for those who survive will be the control of the fund.
Yeah.
And if you have control, then you control the destination of the benefits.
All right. So your area is of control.
Yes.
How difficult is it to set up the control that you're after whilst alive?
Relatively straightforward. It is far, far more difficult to do that after you're dead.
Okay. Yeah. Well, someone's going to be able to do something, and that's the problem, isn't it?
Yes.
Okay.
And typically there will be one side of the family and possibly another side of the family fighting for control of the fund, and that's where families will fall apart, planning will go, intended planning will not be achieved and go astray, and unfortunately lives will be torn apart and unnecessary costs incurred.
Okay, so your hope obviously is to try and negate all of that.
Yes.
What processes do you put in place to try and do that?
It very much depends on each member and their circumstances, but the main approach is to have a company as trustee rather than individuals.
Okay.
The great advantage of a company is obviously it still continues in existence even though the directors may have died. The other aspect is...
So, sorry, can I just ask, so if you have a company as trustees,
Yes.
so who's that company? Like, that's a group of others, or it's your accountant, it's your lawyer, it's your...
No, for the most part it has to be the members of the fund must be the directors of the company.
Yeah.
There are certain exceptions, but that's the main rule.
Okay.
So that when a member dies, that also means that a director has died. But the advantage of a company is that the corporate entity continues, and then it's just a matter of, through the constitution of the company, ensuring that the control of the directors is maintained, and they can then exercise whatever powers they have under the trustee of the fund.
Okay, but if you have two trustees or two directors and one of them dies,
yes,
then the remaining one, they'll be able to do pretty much what they want.
In general terms, yes.
Yeah, I only ever talk in general terms. Specifics, that's for people like you, just general.
Okay.
So isn't that part of the problem though, that if there is one surviving director, then...
Well, that's when you have control at the level of the fund, and you can achieve that through a binding death benefit nomination, so that the member who's died has made a nomination, which is a direction as to how the benefits to be allocated after his death, and the trustee in fact must comply with that nomination, whether they agree with it or not.
All right, and and this is something that can't be controlled after death, is the actual, if it hasn't been set up properly, the destination of the benefit, and that is the problem, isn't it?
Correct, because if you don't have a nomination, the fallback position is a discretion, which is then exercised by the trustee.
Okay. Is it a new problem? I mean, I think families have fought over wills and capital and, what's left for years and years.
Well, in that extent, no, it's not a new problem, it's just a new battlefield. We've gone from just the normal estate now moving into the self-managed super funds and superannuation generally, because there's so much wealth in superannuation. A generation ago or 2 generations ago, there were very, very few people who had superannuation,
yeah.
And those who did were basically in defined benefit plans, which had a very direct sequence of how the benefit was allocated on their death.
Okay.
So it's the same problem, new battlefield.
Right. Which is a great way to define it, actually. From a legal point of view, is it quite an exciting area, because it is relatively new?
It is. The technicalities are interesting. We're sort of, the industry is moving away from just being a very binding death benefit nomination being a very straightforward thing, to being, they can be quite intricate and involved depending on what the person wants to achieve.
Yeah.
And so we're still having, I suppose, discussion with the industry as to what truly are the limits to a binding nomination, how far can you go, what mechanism, what limits can you put in? What controls can you put in?
Do you see a time, and possibly not that far away, that there will be a sort of a set sort of a plan or set of rules that can be created to make it easier for you guys?
Look, yes, but again, it depends on what you want to achieve as the member wants to achieve. Sometimes they do need complicated arrangements because their factual situation's complex.
Yeah.
Other times, that's unnecessary because their circumstances are very, very straightforward, and maybe a very simple, straightforward nomination is the best thing they can do.
Okay, great. Thanks, Michael. Michael Hallinan.
Thank you very much for having me.
Beauty.